Jerry Roth, President of UIA. I am delighted to be here starting our very first UIA Capsule presentation webinar. Thank you all for joining us. We have about 100 participants and others joining. We have over 200 participants registered. I want to thank everybody for being here. I want to thank you for supporting UIA during these extraordinary times. We're working hard to put together programs under these new circumstances, and I can't thank enough the presenters today who have put this program together so quickly. It's an excellent program with terrific content, and I am very, very happy to be here with all of you to observe it. I'll be getting off the screen in a moment, but I do want to thank all of you, invite all of you to keep track of UIA events on our website and through our various social media outreach. And with that, I turn it over to the presenters to begin the program. Thank you to everybody. Bonjour et merci à tous. Gracias y buenos días a todo el mundo. Here in California, it's 8 o'clock in the morning, but I know it's later in the day for many of you. So let's get started. Thank you.
So we start with.
Okay. Good afternoon to everybody. Jean-Paul,
yeah,
would you like to start?
I'm here.
Thanks to Jerry, and also we all agree that it's a very tough moment. Me, as the president of the contract law, I would like to really appreciate all of you, the big effort, and especially to my partners of the International Sales of Good to be here today. And I just give the floor to my good friend Jean-Paul, because all this webinar was his idea just from the right of the moment, and I would like him to explain a little bit to us how it would work, and I hope it's interesting to everybody. So thank you very much for joining us, and hope you get something out of it. Jean-Paul?
Yes, thank you. Hello, everyone. So what we constructed for you is a interactive seminar. We selected 3 war stories. This is how we call them. We will have 3 presentators introducing 3 stories, and for each story there will be 1 commentator who will provoke reactions. For us, the aim is to bring you to the floor, bring you to interact with us. It's not the purpose of the webinar is not a vertical university lecture where we'll just put academic solution on the table. Basically, the stories we have to share with you do not have an absolute legal solution or absolute academic solution. Some of the cases have no solution so far. The idea is to interact with you and to check what would be the best possible way to come over the obstacle. The first presentation, the first story is going to be introduced by Christoph OERTEL, who is a long-standing member of both Commission, Sales and Contract, and I will be his commentator. So I suggest that Christoph, you move with your presentation, and then the way we're going to interact, you will have the possibility to ask your questions, make your comments in the panel, in the window questions, and we will constantly monitor your questions and take them in a row. So Christoph, I suggest you take the floor.
Yes, thank you so much, Jean-Paul. I welcome you as well to this webinar presented by the UIA. And as Jean-Paul just introduced, we have selected some war stories which we have experienced more or less the same, probably most of you out there, if you are dealing in business law during these last weeks. as Jean-Paul already introduced, we are together in this first war story, and I would like to set out the facts which we have encountered so far, and which I would like to discuss with you all. So here's the story of the supply chain, and when I heard of these cases which came to our law firm, I thought of such a movement comparable to a tsunami. What happens when a tsunami arrives after an earthquake beneath the sea? First, you can see the water retreating far, far away. There's there's nothing left of water, but then the flood comes back and you don't know where to go with all the water. So if you are advising clients in the middle of a supply chain, they might have experienced quite a similar experience. So first phase, the retreat of the water. When the Corona crisis started in Asia and in China more precisely, very many of our suppliers have received notices by their suppliers in Asia, informing them that because of the Corona crisis starting back in December 2019 in China, they could not deliver because their production lines were stopped, their workers were sent home, and they were put into confinement. So with this drying out of the supply chain, our clients had to turn against their own customers, in our case in the automotive industry, but you can think of a lot of other industries where the customers requesting the products, but you couldn't deliver them, you couldn't get them, or that your suppliers from Asia would demand higher prices. Now, this was the first phase. And then the second phase is that when the Corona crisis arrived in Europe, finally, or in the US, then we now see that the production lines of the customers of our clients are stopping. They're sending their workers to part-time unemployment. And now you don't know, while at the same time in China, factories are taking up production again, and now want to send all the products which are contractually agreed to you and your client. And now you don't know where just to go with these products because your clients don't take them. You cannot put your manufacturing goods together because there's nobody working in your factory anymore, or it's much less work. So to cope with these two different situations, we would propose in the first place to analyze what happens when your client is unable to deliver. It may still happen today that he just cannot get any products to deliver to his customers. What is the legal remedy presented in this case? A first possibility would be to think of force majeure. Force majeure means an impediment which is unforeseen and insurmountable, and where you cannot perform your own performance. When in the first semester of any law student, you start learning that you first have to look in the contract. So please look into the contracts to see if there is any force majeure clause. A lot of modern contracts do contain such a clause, and you have to carefully scrutinize the conditions under which the contract accepts the exception of a force majeure and the legal consequences, what should happen if such an event occurs in your contractual relationship. So if you have such a clause, you should carefully look whether such a situation of the pandemic is really part of the force majeure, which you have agreed with your contractual partner. And if this is the case, you may have a good case to argue such a force majeure against your contractual partner, your client, the customer of your client who wants to have his products, and to say, well, because of the pandemic, we are unable to deliver, and our performance will be suspended until such time. However, if you do not have such a pandemic situation in your force majeure clause, then things start getting a little bit tricky, because the presence of a force majeure clause would mean that you have thought of force majeure cases in your contract, but you have not thought of the pandemic, and the consequence is that this omission of the pandemic in the force majeure situation will not allow you to argue force majeure. Now, if you're not on the lucky side to have such a force majeure clause in your contract, then you should move to the applicable law. And before you go to your national domestic law, please consider that part of the national law in very many states of the world is the United Nations Convention on Contracts for the International Sale of Goods, the CISG. And if this CISG applies to your contract because you either have made a choice of law pointing out to a national law which has incorporated the CISG, or when the international private law points out to the CISG, you can rely on Article 79 of the CISG, which foresees a force majeure clause, and which gives you an exception for your contract for so long as at least as this force majeure happens. If you do not, because this is a German problem, very often encountered in German law and in German contracts, if you have made a choice of law to a state and excluded the CISG, this is possible under the regime of the CISG, then national domestic law will apply. And here, at least for the German colleagues, I have to say that the force majeure is an unknown concept in the German Civil Code. German lawyers, and under German law, you would have to rely on an objective impossibility to perform, or a disproportionate cost of performance compared to the other party's interest in performance. And these are very high hurdles to argue such a force majeure, and if the German law applies, at least for the German perspective, this will be much more difficult. I would like to point out to the UNIDROIT principles of international commercial contracts. These principles, they foresee a force majeure provision, which also presents an excuse to the party which is unable to perform during the time of the force majeure. Now this, in a very brief way, for the conditions of force majeure, think about the legal consequences. The non-performance will be excused while the performance is hindered. There will be no obligation to pay damages for a late delivery in this case, but a force majeure always foresees an obligation to notify the other parties in due time, and if you do not notify your contracting partner when this situation comes up, then you have to pay damages for the damage caused by this late notification. However, being unable to deliver would not only give you the opportunity to argue force majeure, The other argument, which you can find in very many legal relationships, is the so-called hardship. That means that the performance becomes very much more expensive than at the time when the contract was concluded. And then in such a case, a lot of contracts we make foresee a right to cancel orders or to adjust orders, but you have to agree on this. Again, if your contract is silent about hardship clauses, you have to turn to the applicable law. Under CISG, while there is a force majeure clause, there is no explicit provision on hardship, which gives the other party a right to renegotiate the contract. However, we wanted to make you aware of a Belgian case of the Cour de Cassation in 2009, where the Belgian Cour de Cassation said, well, there is Article 79 of the CISG ruling expressis verbis the force majeure case, but such a provision implies that also cases of hardship are governed by this provision. And the Belgian Cour de Cassation accepted to supplement this missing rule in the CISG by the principles of hardship, and it took these principles from the UNIDROIT principles, which foresee such a hardship provision, which gives the other party the right to renegotiate the conditions of your contract. However, be aware that this is a simple argument. This case is singular as far as we have researched, and it is heavily debated among scholars whether this is a correct application of the CISG. To be complete, I would like to point out again to the UNIDROIT principles of international commercial contracts, and you can see that this is a very modern, very complete set of rules in these articles 6.2.1 and the following. There's hardship regulated. German national law knows something that it's called interference with the basis of the transaction. This is basically the German way to present hardship, and it provides the party the right to renegotiate, not to renegotiate, but to have the contract adapted by the court. And interestingly, Section 313 of the German Civil Code does not give a right to renegotiate among the parties the contract. And I emphasize this problem because now we are coming to the second part, which is the much more open question. If you cannot or do not want to accept delivery because your stock is full and you do not have any place to put it, your customers don't accept your products anyways. So what should we do in such a case? Arguing force majeure will be a difficult thing, because even though if you accept that accepting delivery is a duty to perform for the buyer, it would be a hard case to argue that you're indeed impossible to accept your goods, because it is conceivable that you can store your goods in another place, you can rent other places, or you can find other solutions. So arguing force majeure is not a very safe harbor in this case. The second argument would be hardship. So can you request the adaptation of the contract? In German law, we have learned that it is not possible to request renegotiation of the contract, but to request the court to adapt the contract. However, if you now see that there's a circuit breaker active in Germany, courts are not properly working, this is not a very good solution, because it would take much too much time to have a judge decide on the fate of your contract. Again, we could propose turning to the UNIDROIT principles which foresee that the parties have a right to request the renegotiation of the contract. And in our opinion, this was a very good solution, because solving this problem of not being capable of accepting the goods is not something which has a black or white solution, but you have to look at the individual case and to find a solution. And the request would be to accept such a negotiation. So thank you, and I may turn to Jean-Paul, my commentator, on this, to have the comments and maybe to take up questions which have been asked.
Thank you very much. I am the author of the little blue bubbles on the screen. So very briefly, in order to provoke reactions from you, excuse me, I have to go to the first one. Force majeure, as Christoph said, is basically impossibility to perform. A pandemic doesn't make performance impossible, because in terms of proportion, it's only a portion of the population which is affected. So basically, performance could still be possible. So if pandemic is not in the list of the force majeure, is there any other possibility to integrate the situation of a pandemic under the roof of a force majeure? There might be a decree, as we have now in most European countries. You have decrees of the authorities preventing people from a large gathering, more than 5, for instance, preventing people from being too close to each other, 2 meters distance, etc. And these decrees make it probably impossible to perform certain contracts. So check in your clause, if you have a clause, whether the situation of pandemic could be captured under the heading of a decree, of a ban. Then I had another comment, which is in fact has already been made by Christoph. Be careful if you navigate under the CISG that 79 is a situation of force majeure, admits a situation of force majeure, but only the damages are excluded. The other remedies of the CISG in case of non-performance are still available. So it might not necessarily address the situation in an optimal way. Then I would like to come being unable to deliver. And this is one of the most important bubbles we made with Christoph. Here there is definitely no case of impossibility because the goods are there. They have arrived in the harbor of destination. You have ordered goods from China. They are now in Hamburg, for instance. There is no impossibility for you to keep delivering. Even if there is a reduced capacity of unloading, you might still be able to unload. It might probably be more expensive. What do you do with these additional costs? This is in fact one of the crucial issues which we lawyers should be able to give ideas to the clients. Because none of the parties is in fact responsible for what happens. I am today the buyer sitting in Hamburg. I received a notice that my cargo has arrived. My warehouses are full because I could not deliver the previous orders. I cannot take on new material because my warehouse is full. Do I have additional warehouse possibility on the harbor? Do the customs function? Can I go to the customs to make all the custom formalities and to clear my goods to enter in Germany? I don't know. If so, what are the additional costs? Could I just say to the ship owner, please stay for a couple of weeks in the harbor of Hamburg, keep my goods on board. What about the additional costs, what we call the demurrage costs of having the goods on board a vessel? So this is frankly the crucial issue in the second part of the story of Christoph. Nobody is responsible for this. You do not have the possibility to take on, you do not have the possibility to sell further down on the chain. You have additional costs. So here I would like to open the discussion to receive your comments and questions on how do you see this possibility to address this new situation. We open the debate.
Thank you very much. So the chat is open, and let's see if there's some question. I think for the time being, while the questions are accumulating, we could move on, shouldn't we, to the second war story? So we keep our time.
Yeah.
Okay, we'll move on then. Oh, we wait. Would you like? There's some questions here for you, Christoph. I don't know, Jean-Paul. Would you like to take a look?
If you have the questions already, maybe Christoph should answer them.
Yeah.
Christoph, can you see the questions or?
No, I cannot. In the chat, I cannot see a question yet. I don't know. I don't know whether there is a question.
Okay, we have a few questions. I can see them.
Okay.
Here's a question from Ian de Freitas. Interesting issue about whether national courts are still open to judiciary consider these issues. Can you tell us about if courts are open in Germany or in Switzerland?
Yes, well, in Germany, basically the courts are working, but they're working at reduced capacities because, in particular, the staff is not always present. So you will get easily very large extensions of deadlines, and courts are working more slowly. However, what is kept up are issues that need speedy reaction, but this is capacities which are mostly reserved for criminal law and for question of detention or not. So courts are working at a much slower speed at the moment in Germany.
We have one question, at least on my screen. Force majeure is defined as an act of God, but this virus appears to be an offshoot of an experiment in Wuhan gone wrong. So can it be defined as an act of God? In fact, the source, in my understanding, the source is not necessarily relevant. It is rather the impact. If it makes your performance impossible, it could qualify as a case of force majeure. If you go to the definition you usually have in the clause of force majeure, it is, of course, you have a list of examples such as floods, earthquakes, etc. But you have the general definition: the event makes your performance impossible. You cannot resist. It was unpredictable, and you cannot resist or overcome the consequences. In fact, as I said before, the pandemic does not affect 100% of the production lines, but probably the decrees of the authorities to protect the entire population, and these decrees would block entire sectors of the production. These decrees could be seen as acts of God or creating a situation of impossibility. I don't know, Christoph, if you agree with me.
Yes, I do. Indeed, I do. And if the clause itself gives the correct examples, then you would probably look at the outcome, and you would have to check the conditions of the unpredictable and insurmountable event.
Okay, any more questions? Jean-Paul?
There is another question from Damer Hami.
There is one comment. There is one comment which is absolutely correct. Act of God is only one instance of force majeure. This is absolutely true. In fact, coming from the civil law countries, we focus more on the effect, the impact of impossibility. We do not give so much importance to the notion of act of God. Just look at the impossibility.
There's an interesting question here, Christoph and Jean-Paul saying, can you clarify the difference between the two concepts, hardship and force majeure, please, in 2 lines?
Force majeure, your performance is impossible. Hardship, it has become extremely hard, but not impossible. Extremely hard, usually in terms of additional costs, excessive burden.
For instance, if you come back to this Belgian case, there was steel tubes being sold from the seller to the buyer, and between the conclusion of the contract and the delivery moment, the steel price had gone up in 70%. And this is exactly the difference. It's not impossible. So the seller could deliver, but at a very unattractive price for him. But his performance got very much more expensive. And this was hardship.
Okay, there's a last question here. Jean-Paul, can you see from Tamer Funny? Finally, according to the unknown period that we cannot expect it for the cargo delays due to the COVID-19, how we can advise our clients to do if these circumstances take a long time and not end it shortly? What would be the advice for our clients in the meantime? I guess that's the question.
I didn't get the first part of the text. I don't have it on my screen.
Is it okay? Finally, according to the unknown period that we cannot expect it from the cargo delays due to the COVID-19, how we can advise our clients to do if these circumstances takes a long time or not end it shortly? What would be the advice on how to act in the meantime until they can reception the cargo, or either way, not accept the cargo? What would be the advice in the meantime?
Mm-hmm.
From your point of view.
Yeah, this is extremely delicate, and this is what I warned when we opened the webinar. There are some questions where we do not have absolute answers, clear-cut answers. Probably you should try to identify all possibilities around you to unload, because one of the first critical issues is that you have the goods on board a ship, and this costs a fortune. So a first question, is it cheaper to send the ship back to another port to unload in another port, or to try to unload close to your port of destination, perhaps with additional costs? In fact, the mechanism of a force majeure clause or even hardship clause is to suspend the performance and to observe how the things develop. And today, this is really the core issue, is to use this time to observe and to check every possible option, to compare in terms of costs, and then to negotiate between two parties who can take what portion of the cost. It would be unfair to say 100% on the shoulders of one party or 100% on the shoulders of the other one. So this is where we are out of a solution of law. This is just about economic re-equilibration of the contract. So this is where I would have loved to have solutions or to have ideas coming from the audience, because you do not have a very strict way. You do not have one clear-cut avenue.
Okay, thank you. Let's move to the second war story, which I think, because I'm not really running out of time, I would like to present now my colleague Susanne MARGOSSIAN. Thank you very much for being here. We are lucky because he is one of the in-houses that is risking to be here to give her point of view about what's the situation. We don't have many companies now willing to talk, so thank you, Susanne. But I think it's very interesting, the story that she will put on top of the table, because this is what's really happening. So I let the floor to her, and so we'll just come to a briefly story so that you can more or less have an idea where we are and open to discuss again. So please, Susanne, thank you.
Okay. Thank you, Milagros. Thanks everybody for attending, and thank you especially UIA and Colette for making this happen, to allow us to exchange in these unusual times. So I very much like the last question, last comment, because it's a very good transition to what I will tell you. I'm supposed to give you a little bit the point of view of the industry, of the companies, of the way things are happening right now for us. I'm the head of legal department of the Novalak Group. Novalak is dealing in baby food, a complete, innovative, and healthy line of baby foods. They're distributed all over the world, all 5 continents, not all countries, many countries, over 60 markets. As for the manufacturing, they are either manufactured in our factory or we subcontract to other manufacturers. The sector itself, the baby food sector, is rather lucky compared to Christoph's example, compared to many other businesses who are faced with factory lockdowns and other problems, because we are a protected sector with somewhere in between health products and food. Business continues. There are a lot of exceptions. Our factories are running. Production is going down. Is going on. Sorry. Nevertheless, doesn't mean that the crisis is not impacting us. So what are our main concerns now? First, of course, is to protect the employees and to avoid spreading the virus. So that takes a lot of reorganization. I won't go into details. Then we have to respond to an increasing demand. It's not only our activity is not slowing down, we are actually our engine is in overspeed. Sales are increasing everywhere. I don't have an explanation for that. I think that consumers are not always logical. I don't think babies are eating 3 times as much, but people are stockpiling products, are afraid of shortages, and so we face a very high demand. And the most critical issue, and we heard that already from the comments on the previous presentation, are logistics and transportation. This is really critical and impacts us very significantly, whether be it to be able to obtain containers in food grade quality, to get a ship, to get a place on the ship we're fighting, or even to get the workforce for handling and unloading or loading the products, because these are usually interim workers and they're not available. So delays occur and costs arise, all of these situations. So far, we have not had situations as in the previous tsunami that we had an outright clear-cut non-delivery situation. Us, it's more like the sand in the gears that is on every end and every edge blocking the process. Since the pandemic is affecting all the countries of the world, And every country, every authority is imposing these restrictions individually. There are problems and glitches at every end. With suppliers in different countries, with clients in different countries all over the world, everything is affected. You have to consider also that supply chain is not just supplies. I mean, you have to source ingredients, you have to source packing materials, we have to do gas flashing, controls analysis, deal with export regulators and authorities, and much more. Sometimes you cannot deliver or you cannot honor your commitments to everybody, so you have to make choices. So the impact of the pandemic is, for us, it's multiple and rather indirect, which makes the legal analysis so much more complicated. I'll give you an example. I received a call 2 weeks ago saying from one of our operators, we're way behind schedule with a certain product, we cannot deliver, we're late, the client is not happy, there are stock outages in the market. You have to write a letter invoking force majeure, saying it's force majeure. So, okay. So I tried to analyze the things, to get some more information, to see why are we really late and what is really happening. So I'm trying to, no, somebody played with my slides. Here we are. So this is the situation. The manufacturer of the product in question is in Spain. And this is a contract manufacturer. It's a new production site we launched last year. And as it technically and logistically and otherwise difficult to launch a production site, there were delays. So the manufacturer was late in delivering the products. Another thing, it's stupid, but that's reality, is that in order to deliver to the world from Spain, you need to be registered and identified for VAT purposes. Now, during the crisis, I wasn't able to find a notary public in France to legalize my proxies. I found a notary in Geneva, but the registration services are closed and the courts are closed, and I cannot get the apostille, so I cannot do these stupid formalities to ship my products. I have to ship them to my warehouse in France and ship them from there. Another thing is, once the products are manufactured, which they finally were, they are analyzed and released from the manufacturer. And then we do extra controls and checkups by official independent laboratories. One of them is in Italy, and the other one is in France. Now, the Italian laboratory never received the samples because somewhere on the way, the transporter was blocked. He refused to go to Italy because there was a cluster of the crisis at the time. So we had to find another transporter, but nevertheless, the laboratory is working slow motion because of lack of personnel, and so it all adds up. You have one delay after the other, and who's to blame? In the meantime, as I said, demands skyrocket, and the clients are out of stock, the markets are out of stock. Yes, this is a very sensitive product for babies with severe allergies. People are worried. There's no more product on the market. Now, the result of this, of course, is that that delays and the possible claim from the distributor for damages. Okay, this is the story. Now, what are the possible ways to handle the matter? Of course, you do your legal analysis. This, like Christoph very well explained, the different options you have. You try to slice up the responsibilities, to look at all the contracts, all the actors. You have to collect all the documents, not only the contracts, but also the order forms, the receipt of the orders, the invoices, to see how late are we actually, who is where, the correspondence, and then find out it's not so easy because everybody's in our company working from home, and access to documentation is not that obvious. Once you've done that, you check your legal options. We went into those. You look at the contracts, you look at the law. Can you invoke force majeure? Can you invoke hardship? Can you invoke the other party's non-performance? And then you can also look at the special decrees that most countries took. For example, in France on 24 March, there were several ordinances taken by the government, which froze the sanctions on delay of delivery. This is very simplified because they're very technical and complex, but it created kind of a super force majeure. But the more you look at this, and we've seen this also in the previous example, that any legal action you take is uncertain and bears risk. The lawsuit afterwards may take years and years, and actually the situation is unprecedented. Nobody knows how a judge will look at this, and with hindsight, it will always be easier to say, yeah, well, you should have done this, or you should have done that. It may take years and years. There's no case law. Nobody knows. In this respect, no contractual clause or no legal advice can solve all the problems that you have. So what do? You need to find solutions, and you need to find them quickly, and you need to find good solutions and pragmatic solutions and be creative. And you have to make choices. So in this example, you have to set your priorities. Everything that takes more effort, more work, and that may induce some costs, it's okay, you do it. For example, what we did here is, in order to save time, we shipped the goods to the client, although they were not released by the laboratory, waiting for the analysis to come through, which is, of course, an additional cost. And then they were blocked in the client's warehouse. We call it in quarantine. It's an additional cost, and it's a risk for us, because if there is a problem, we have to ship them back. But it saves a lot of time because you have things done in parallel. Of course, we had to find another transporter for the Italian lab, with looking at other laboratories in less affected countries. We accelerate production, we accelerate wherever we can, and do everything possible. One thing you cannot do, or we will not do, is compromise on quality. One could imagine saying, okay, these products, they have been analyzed and released by the manufacturer, they're good to go. You double, triple checking everything. You need to, it's urgent, you need to save time. But that's an absolute no-go. Whatever the cost, you don't play around with safety or quality issues. And what the other important, very important thing is communication and information with the client, with everybody, and total transparency. This is, anyway, it's foreseen in most of the contracts and most of the force majeure clauses, and these are your contractual obligations, but also it's common sense. The better you communicate, the more transparent you are, the better you can handle this. Just for the outcome of this case, so you can easily see that the first reaction, if I had written just a letter to the client saying, yeah, we're late, but it's force majeure, hey, it's an exceptional situation, I think that would have been a boomerang, very right back in our face. It would have been very unconstructive and risky for the future. Especially because after careful analysis of all the documents, I realized that it was much worse. Actually, the manufacturing of the products was much more late than we thought. They should have been delivered in December already. So no way you can blame this on Corona. This was mainly due to the Spanish manufacturer being late. Does that mean, so that means, okay, then I just attack the manufacturer, then it's all his fault, which raises an interesting question because, okay, he was late in the beginning, but then because of the crisis and the pandemic, everything is amplified and all the other delays added up. As for the first delay, maybe we could have absorbed that. So is that a foreseeable damage? Most systems, the reparation of damage needs to be foreseeable. So just to finish the story, the goods were released on Thursday, and thanks to our good communication with the client is happy actually and grateful for all the efforts we made to overcome the obstacles and that he can have the goods. So that,
okay, thank you, Susanne.
Just key considerations are very, very short. So as you can see, it's important to negotiate. It's important to go back to the contract and then to renegotiate. To think long term, you have to sanction the relationship. If even if legally we would have been right maybe to blame it on the manufacturer, which is not certain. This is it's a relation. Our manufacturers, we work with them for 10 years, 20 years, 30 years. It's normal that if you launch an activity, that there are some hiccups and that there are some delays. So if in the first year I jump at him and come down on him because there are some problems, I'm not going anywhere. And the same is true for the distributor. This is also, these are also long partnerships and relationships, and nobody's black and white here because the distributor is not really performing very well his contract either. The medical reps are not moving. they can't visit the doctors. There's no conferences. There's no congresses. Medical promotion is on hold. So everybody has problems. Nobody is performing correctly. And what you have to do is you're all in the same boat. You have to find practical solutions, creative solutions. And just one last comment. Think also of acting in good faith. Whether you invoke force majeure or whether you are late, it is a concept that is not only reasonable but also legally important. There is case law in France where the supplier was obliged to renegotiate the distribution contract, not under hardship, but under the obligation of good faith, because the conditions had changed so much that it wasn't reasonable to continue as is. So Milagros, I leave you to comment or question. I don't see if there are any questions from the audience, but
okay, thank you, Susanne. I would just like to bring your attention to two very important things that Susanne just said. And actually, when we were preparing this war story, we end up both saying that good faith, it could probably be one of the most important things in long-term contract and relationships. Obviously, there's always people taking advantage of the situation, as Susanne was telling us. And we can see when we work globally with many different countries and many different situations, there's always tiny things that we don't accomplish as we should. Like in this case that we were explaining, we have the manufacturer in Spain, which was late on the first place. We also have the problem that arises because of that. And we also had another problem that Susanne pointed at, which is very important. Everybody went crazy for buying the product because it was a very special product. It was for allergy babies. I know, of course, the parents were very afraid of running out. So then we could say that the situation that provoked the COVID was very extreme. But the real truth is there were many things happening in between the two. So yes, I think we should take a look carefully, and as legal advisors and also for big companies, I think we need to breathe firstly and think about what we can do apart than applying for force majeure if there's no other chances. And that's very important. And also, as what Susanne was saying, in long-term relations, it's important that we construct something that can last for longer, and probably will be better if we can give tiny solutions in each case instead of applying to huge cases, which obviously we'll have to deal with. But I would say in the first place, our commitment as lawyers and as advisors will be to try and give a help to the in-houses and also to our clients. So I leave to the audience and see if there's any questions that you would like to ask to Susanne, and we're open. Here there's a question from Gulati saying documentation is the certification will be a part of the purchaser's responsibility. How should it be a force? How would it be a force majeure? Susanne, can you see the question down in the?
No, I can't see it.
Documentation and its certification would be a part of the purchaser's responsibility. So how would it be a force majeure?
I'm not sure I understand. If you're making allusion to what I said about the notary public and registration for VIT, I mean that's purely that's purely our responsibility. I mean that's a tax matter actually. And in other cases, it depends. It depends on what documentation you're talking about. Some is the supplier's responsibility. Some is the responsibility of the purchaser. But it's a good question. I don't think. I think it's very difficult to qualify that as force majeure. It doesn't make it impossible. Does it make performance impossible? Hard to say.
Hard to say. Yes, agree. Okay, thank you very much, Susanne. I think it would be better that we move to Steve and Francisco, and so that we can have a different perspective now from common law perspective, which is always something that we need to hear. So thank you, Stephen. Javier, I leave you the floor. Thanks. So Javier, you start presenting Steve and...
Yeah, sorry. So thank you all for attending. Stephen Sidkin is partner in the London law firm Fox William, and he's an expert in international contracts, and he would provide, as Milagros was saying, he would provide a very interesting perspective about all this situation from common law. So Steve, the floor is all yours.
Hey, thank you very much indeed. Good afternoon, everybody, and thank you to all of the previous speakers. I've been asked to talk about a common law perspective as part of the war story, or the third war story this afternoon. The war story is very much not a war story as such, but a series of thoughts for you concerning the common law approach to force majeure. And hearing what has been said by Christoph initially and then by Susanne, there are many things that, as a common law lawyer, I can relate to, but also some differences. One that stands out, and I'll touch on it now before I forget it, is that there is no concept as a matter of English law, hardship. The fact that it may be more difficult for parties to perform because there has been a movement in commodity prices which causes the party a problem. English law is not concerned about that. the courts will not intervene in order to remake the commercial bargain between the parties. And perhaps the brutal reality.
Excuse me to interrupt you. There is a little problem with your sound, I think. We don't hear you well. Sorry.
This is as good as it is.
Can we try again?
Sure. Where from?
Yes. Okay. Thank you.
Okay. So as I was saying, what the issues that I will touch on will, I think, highlight the brutal reality of the common law when it comes to the situations where it can arise. But let me start, if I may, with a prologue. Two companies, both alike in dignity, in fair webinar where we lay our scene. From ancient contract, break to new disunity, where COVID-19 makes parties' hands unclean. Well, perhaps it is fair to say that the UK government 3 weeks ago, perhaps even more recently, was encouraging washing of hands, although I think he was doing so more with regard to trying to avoid the spread of the coronavirus than having regard to force majeure. I put up, or in fact, Javier may have beaten me to it, on the screen, some examples, and I've called them recent examples. In truth, one might say they're quite old. They go back to 2011. But in each of these situations, what we do know is that common law businesses, Freeport McMoran, which is a US company, Shell, an Anglo-Dutch company, Air Liquide, although it's ultimately, I think, a French company, it was a UK subsidiary which was seeking to rely on force majeure. In each case, force majeure was claimed, it was pleaded by the parties. What I can't tell you is whether or not in each case the parties concerned were successful. I don't know. I've not been able to track down any published judgments involving any of these matters. What I can also tell you, however, is that since the start of coronavirus, in terms of it being an issue which is affecting businesses around the world, it is the case that here in the UK, very few companies have actually started to rely on it. Why is that? It's a good question. And I think it in part relies on the issue of the companies concerned looking at their contracts and then thinking, oh, can we rely on it? Why is that? It's because when we look at force majeure, we usually find in an English law contract, the force majeure is at the end of the contract. And furthermore, it is a clause that the parties have included in the contract without thinking about the circumstances in which it might be used. It follows that it's therefore important in terms of contractual obligations to look at the force majeure clause itself and then the circumstances in which it is said, and the circumstances have resulted from the occurrence of the force majeure event. What we know is that regularly we see in a force majeure clause reference to war. And we can point to judgments in the English courts where war has been argued successfully as being an event of force majeure. Strike, similarly. Riot, yes. Pandemic? Not sure. We're not sure because we rarely have pandemics. We're not sure because, even more importantly, pandemics are rarely referenced in a force majeure clause as a matter of English law. So what is important is the ability to rely on the force majeure clause in order to justify your own non-performance. And let me give you some examples as to why that might be an issue in itself. Given the time frame that has elapsed since the effects of the coronavirus pandemic became public, can it now be said that an event is out of the control of the parties, where possibly, I'm not saying definitely, and clearly it will not be a case that it happens in all situations, but depending on the facts, could the parties have taken steps to mitigate, to reduce the effects that coronavirus would otherwise have? Could it be said, for example, that a supplier should have lined up alternative sources of supply? We don't know. A party considering relying on force majeure to justify non-performance should give thought as to how it would be possible to show, how it would be possible to demonstrate that it is legally or physically impossible for it to perform its contractual obligations, not simply that it's unprofitable, not simply that it is more difficult to do, but that it is legally or physically impossible. And whilst thinking about that, a party to a contract has to, in my view, look as to whether its counterparty is looking to rely on force majeure. It may be willing to perform the contract, but what about the counterparty? And the counterparty may actually seek to rely on force majeure in order to try and avoid its obligations. And this is so where it's possible, for example, to think of an installment run of a particular product could be affected. Susanne has already made reference to problems with factories, but yet other production runs might not be affected. So to what extent is force majeure affecting the counterparty? Will it look to try and get out of its obligations so far as force majeure is concerned? So if we go then to the next slide, let's go back there, sorry. So some years ago, Bill Clinton said and won the US presidential election by saying it's the economy stupid. To my mind, it's the contract stupid. Because if you don't, as an English lawyer or as a common law lawyer, look at the contract to look at what is there, everything else is off. And the starting point is not the effect, which I think was referenced by one of the other speakers earlier on in this webinar. The starting point is, what are the events of force majeure referenced in the force majeure clause, before you then consider the effect. It follows that as a few, I suppose, take-home points from this webinar, from an English law perspective, the starting point for a party to a contract is to check the contract and have a look at, first of all, is there a force majeure clause in the contract? Does coronavirus come within the definition of a force majeure event? Is there an obligation to give notice if a force majeure event occurs? Simply because the event is referenced in the clause doesn't mean that you can automatically avoid your contractual obligation to give notice of your reliance on it. Is there a maximum period during which obligations of the parties may be suspended? Does this apply to both parties' obligations, or only the party whose actions are affected by the impact of coronavirus? And I mention that because often what we see in force majeure clauses in English law contracts are periods of suspension. so the parties do not have to do anything for 30 days, 60 days, whatever it is. The difficulty here, of course, is that we do not know, any of us, how long the events or the effects of force majeure, again, as a result of coronavirus, are going to be with us for. So what then happens? Because the next point to think about is whether there is a right to give notice to terminate the agreement if the force majeure event continues for a certain period of time. And is this a right which is only a one-way right, or is it a right which both parties to the contract have? Again, an issue which should be spelt out in the force majeure clause, but often isn't, and often isn't because the clause itself is what I would call, from an English law contract perspective, an orphan clause. No one likes it, no one wants it, and it's been put in the agreement because no one wants what might be the events and what might be the consequences. And then I suppose in terms of just a few further points, what happens if you receive notice from your counterparty that it is seeking to rely on force majeure, or is giving you notice having relied on the force majeure clause? What should you be doing in order to mitigate your loss? If you or your counterparty agree as to the coronavirus constituting a force majeure event, whilst this may be an opportunity to bring an unfavourable agreement to an end, it is also a question of being careful what you wish for. You need to have a backup plan. Do you have another counterparty in place that could step into the contract and perform it at short notice? Do you need to conduct an audit of your new counterparty? And are there contractual obligations that you're tied into, perhaps with regard to non-compete, that could be impacted by a change in your contractual relations? A huge range of issues which flow from a simple clause which no one really loved, no one really wanted, and most importantly, rarely does anybody think about. If there are any questions, try and answer them, but otherwise, thank you all very much indeed.
Thank you very much, Steve. Milagros, if there is any question, I just would like to pose a small question or comment, which is regarding on equity. And I will pose it in a way of example, with a true example. We have a client who is, he has a, it's not clear if it's force majeure or rebus sic stantibus clause, but it says that in the case of an extreme event, and it includes pandemias, both parties would negotiate in good faith the terms to make them balanced again. And if they do not reach an agreement within 15 days, our client can terminate totally or partially the agreement. No? So the issue that we are facing now is that the counterparty attorney says, okay, I completely agree with your interpretation of the clause, but I'm truly sure that the situation is going to be so dramatic and courts are going to be so overwhelmed that they are going to decide on equity, and they are going to completely ignore the clause, completely ignore the law, and they are going to take a 50-50 decision, and they will make you, okay, I will not get a full indemnity, but just 50%. So, which to me, it's completely impossible that this may happen. But I would like to get your insight if that could happen in the UK, having a clause in this sense, and in this regard. And the same question would be, if we do not have a similar clause in the contract, would the judge decide on equity on the UK?
And also, let me deal with it in reverse order. If there isn't a clause in the contract, a force majeure clause in the contract, the parties may seek to rely on the contract having been frustrated, which I think that Jean-Paul, from a civil law concept, may have said something which I took to be a common law frustration situation. But frustration itself, as a matter of English common law, is incredibly difficult to rely on. So much so that we are taught at university, we are taught at law school, forget it. It's there. It gets mentioned. It has been mentioned by many commentators here in the UK over the last few weeks. In my view, the chances of being able to rely on it, it is the equivalent of coming to the UK and not finding it raining somewhere. It's just not going to happen. In terms then of will the courts then look to equity, they will not look to equity. Yes, a judge may make their own determination of what are the damages, what is the loss that has been suffered by a party, but that is about as close as we get, and whether the judge has taken an issue of fairness into the judge's mind in reaching that decision, we will not know. It will be what the judge determines based on the evidence put forward as to what is the loss. But there's also a risk here, and it's a fundamental risk. If you and I are in a contract, Javier, and I seek, and it's English law contract, apologies, I know you would prefer Spanish law, but life is life. If you and I are in a contract and I say that something has happened and there has been the occurrence of an event of force majeure, and you say I'm wrong, then by my relying on the what I claim to be force majeure, if I'm wrong and we go to court, then I expect you to argue before the court and to succeed that by my wrongly claiming force majeure, I have repudiated the agreement. It is as if I have stood in front of you and torn up the agreement in front of your very eyes. And as such, the consequences of my doing so will be played out in terms of the damages that will be awarded to you for the loss that you have suffered because I have walked away from that contract.
Okay. We have a. Well,
Any other questions?
Well, Ian asked that for Steve. I think we have to come back to Lord Jennings. Anyway. So thank you very much, Steve. I think it was very interesting to have your.
Okay, thank you. I think we're running out of time, so we should just start ending because, as agreed, it was an hour and 15 minutes, and this is where we are at just right now. So just two final remarks, which would be the first one to thank you all for being here today. I think we'll be better next time, always learning. This is exactly our first experience to all of us. So we're really happy that we had the chance on doing it. So that's the first thing. We need to thank you very much to the audience. I think we've had quite a number of attendees today, which is quite scaring. I don't think that we ever dreamed when we did it in live of having 160 or 170 attendees on a row. So that's another question. My final remark as a lawyer would be good faith, and good faith. This situation is amongst all of us, and we as lawyers, I think we are responsible for a better world. So I just leave the floor to my really good friend Jean-Paul, who would like to do his final remarks. And just from my side, thank you all.
Yes, I just have two information. First of all, thank you very much to all of you for all the questions you have put. I have tried my best to answer most of them, at least those which lie in my sphere of knowledge. One question is especially interesting, looking to the future. One of the participants asked, how shall we work now with the future risks which we think would derive from the current crisis? And my answer is integrate all possible risks you identify in your contract. Never forget for the future that a contract is the best possible instrument for the allocation of risks. So the more risks you identify, the better it is to allocate them immediately in the contract in terms of cost bearing, cost sharing. Do not let any risk unattended, unaddressed. If you see risk today, address them in your contract. The contract is really the place where you can address the risks. So this is my final word. Thank you so much.
Susanne, would you like to say something?
I'd just like to add to that, when we do our new contracts, I think we're going to think again about hardship clauses and force majeure clauses. I think have gained some consideration, but also first of all, more immediately think about new contracts which you are concluding right now. There's no more force majeure now, because now the crisis is everywhere, everybody knows about it. So I think for contracts that you're entering right now, you should think of integrating tailor-made corona crisis and name it, and imagine the risks and allocate the risks to the different parties and address them this way. So this is my final remark. Thank you, everybody.
Javier or Christoph, would you like to say something for final remarks?
Yes, I would like to thank all the attendees and all my fellow moderators and commentators. And what for me was the most important takeaway was also to have the insight of a corporate counsel with Susanne, because it shows to me that handling this crisis is not a question of applying concepts of law which we know now, which we all have studied, but now it's a question of finding creative solutions which help both of the contracting parties, which should not act, and we should not in the first place understand our partner as the opponent in these situations, but as a partner with which we have to find solutions. Otherwise, we will lose much more business than we will win when we have some small victory on our case in this place. It was one of the most important takeaways for me.
Absolutely agree. Steve, would you like to say something?
Yeah, sure. Following on from what Jean-Paul said and Susanne said, the contract is key, the clause. But I think also for the future contracts, the worrying thing is, of course, what we don't know. So perhaps the answer is to try and find someone who has written about the future, a futurist, which tells us what will happen, what we should be worrying about. Then try not to worry about it, but try to provide appropriate provisions in our force majeure clause. And I do hope that one of the things that does come out of what we're all going through at the moment is that force majeure clauses going forwards will cease to be orphans and will become loved clauses of each and every contract that we write. And my thanks to all the speakers, my thanks to you, Margos, for chairing it and moving us forward, and to the UIA Centre, who I know have put in a lot of effort in order to make this webinar possible.
Okay, with no further questions, thank you all. Thank you very much to all the attendees as well. And of course, thanks to the OEA, which has done a huge effort to be here today. It's not easy to deal with this situation, but I think we've done it our best. So, thanks to the partners. So with no further things to say, thank you all. Have a nice afternoon. Big hugs to everybody.
Thank you, everybody.
Bye.
Bye-bye.
Bye-bye.
Bye-bye.